Hey everyone, Dan Mckenzie here with the Mckenzie Law Firm. We are an estate planning, estate administration, and small business counsel law firm in the Denver, Colorado area. And one question that we get a lot, probably in our top three, that might be understating things, is why would I want a living trust? A lot of people come in here and have kind of heard maybe they should have a trust. Somebody else had a trust, maybe they're a beneficiary of a trust and it went well. Just a lot of suspicion, I would say, that I need a trust, but not exactly sure what it is or why. So thought I'd make a video showing, where does a trust fit into a typical estate administration process? Again, I always kind of start from the end, right? It's what are we trying to accomplish here as far as how do we want to get things to people? That's the question everyone needs to ask. Like whether it's a will or a designated beneficiary instruction or co-titling assets with somebody else, whatever, there's several ways to actually get, gifting it to them, right? Just give it to them. So there's a lot of ways to get assets to other people, which is kind of what estate planning is really about. So a living trust is one tool. It's not for everybody. Some attorneys do think everyone should have a living trust. There are certain states where that is true. I think in Colorado, the consensus among estate planning attorneys really is that a probate process is not bad enough that everyone should have a living trust. There are some states where that, unfortunately is true. So people do set up living trusts in other states. So if you're watching this from somewhere else, just be aware this is very state specific, and even in Colorado, circumstances can really affect whether or not a trust makes sense for you. But just beginning again from what your options are for getting an estate plan in place, you actually have a number of tools available to you here to make all this happen. Okay, so it's not just a will, it's not just a trust. There's other things going on. So like I said earlier here, we have potentially co-titling assets with people. That's one way to do it. Of course, married couples, very typically, most married couples co-own most, if not all, their assets that they can. So they're both on the house, they're both on the cars, they're both on the bank accounts. A primary reason to do that, of course, is that if anything happens to one member of the couple, the other member of that couple can just carry on, keep managing that asset, keep using it, keep accessing the cash in the account, keep driving the car, keep registering, insuring the car, keep dealing with the house, whatever they need to do. And they don't really need to go through a process necessarily, even if the other person is either out of commission or has passed away. Sometimes people will use this to actually get stuff to kids too. They'll co-title assets with their kids, thinking, well, when I pass away, now their kid just takes my house because they're already on the deed anyway. They just need to record a death certificate. It does work. I mean, it does accomplish that. Big caveat, there are some very important reasons why you would not want to do that. One is creditor issues, opening each other up to potential creditor issues. If either you get sued, if somebody gets a big medical bill they weren't expecting, that can cause real problems. A divorce, unexpectedly, if my name's on my parents' house and my marriage goes into a divorce situation, that's one of the assets I have to list. And could be at issue. So lots of reasons not to do that, and there's also some tax implications of putting someone on a deed, right? You've just made a gift, you've potentially given them your capital gains basis, so there's just don't do it without talking to a lawyer and maybe an accountant first. But within married couples, it is very common, of course. And then number two is designated beneficiary forms. So these very commonly show up, of course, on life insurance and on retirement accounts, because typically as you're setting those up, they will be asking you, well, who should get this if you pass away? It's kind of part of the process for getting those in place. Other assets can have designated beneficiaries too. In Colorado, there's something called a beneficiary deed that you can actually record and put a beneficiary instruction on your house. The DMV has forms for putting beneficiary instructions, attaching those to your cars. Bank accounts, checking and savings, you can put POD or TOD, which payable on death or transfer on death instructions on those accounts, accomplish kind of the same thing. And so again, very fast, very easy for assets, especially again in married couples where you can't both be on it, like a life insurance policy, maybe, or a retirement account. Usually the spouse is the first designated beneficiary, but that has less complications than the first one, the co-titling of assets. And so very common that we will use, you'll have designated beneficiaries on certain assets, and it's just really important that you keep those up to date because they are not superseded by anything else other than the asset titling. So if your will says something different, if you had a different plan in mind, if it's not up to date, it can be a big problem. But in general, designated beneficiaries are great because they're fast, they're pretty easy. People might need that life insurance policy quite quickly. That's usually why you have life insurance, is to get that cash out to people who would need it very fast. We don't necessarily want to wait for a court to figure out, who gets what and all that kind of stuff like happens in probate. Okay, and then number 3, I'm going to put actually entity here. And within entities, there's a couple different possibilities. One is that you have a business, but this is also where a trust could sit, if you have a trust. And so I analogize these two things quite a bit, actually. I think people are more familiar with businesses, right? If you have a money-making idea, you go out and you set up a business, and there's several reasons to do it, but one of the primary ones is I'm trying to get separation from me, right? I don't necessarily, like if I'm out there operating a store or a rental property or something where people are coming into physical space especially, but even situations where, I'm dealing with customers. I mean, if any dispute arises, if anybody gets injured on my property, anything like that, I want to make sure that, the business that was, the reason for that relationship is the thing that's liable and not necessarily me personally. Now, there's a lot of stuff that goes into that analysis. It's very easy to set up businesses in a lot of states. In Colorado, you can set up a limited liability company, for example, with a quick form on the internet at the Secretary of State's website and a small fee, and you've got a business. But that alone is not going to give you asset protection, right? It'd be terrible if we lived in a society where you could just pay a small fee to the Secretary of State and offload all your liabilities. So there's more to it than that. But the point is that this is a separate thing from you. It might have a bank account titled in its name. It might own assets. It might be sign the lease for the space, like everything else. It might be the landlord for the tenants, all that kind of stuff. So businesses, I think, like I say, people are very familiar with that, of course. A trust, the limitation of a business is that it's for money-making purposes, right? It's like, you can't just set up a business and then plop like all your personal assets in there and get that kind of liability protection. Again, there's got to be limits here because, you might be the one that's suing. You might be the one who got hit by the car. You might be the one who feels like you got misled or defrauded in some way, and you don't want people to just be able to hide behind businesses that don't really do anything other than hold personal assets. So really can't put personal assets into a business and get asset protection out of them or any other benefits, really. There are exceptions to that, of course, like everything, but businesses are for business. Trust, on the other hand, is an entity that you can set up for your personal assets, and that's really usually why it's there. And when we are talking about trusts in this context, the most common kind of trust we're talking about here is, of course, the revocable living trust. That's usually what we're being asked about. And the reason for the revocable living trust is you put your assets in that thing. It is an entity, sort of like a business, separate from you. And so rather than me holding my house as Dan Mckenzie the person, I create the Dan Mckenzie Trust and put my house, title it to that thing. And I run the Dan Mckenzie Trust. I'm the only person who benefits from the Dan Mckenzie Trust as long as I'm alive and able. So there really isn't any restriction on what I can do with my house, even though it's titled now to this thing. The purpose of this thing is that if anything happens to me, the owner of that asset is always alive and well, just like a business, right? When Steve Jobs died, Apple didn't die. Apple and Steve Jobs were two separate things. And so a new CEO stepped in and took over, and it continues to flourish, right? So that's kind of what my trust enables me to do, rather than somebody's got to go out and figure out where's all Dan's stuff, and we got to get a court authorization because he's no longer here to sign deeds or pay off loans or all that kind of stuff. Like, the trust owns it, and I can just say in my trust, here's who steps into this thing and manages it for me. Okay, and so the thing to understand, like, next on this list is the will. And like, if you have a will, it only controls what's left after we've gone through these first three steps. So the will, when you think about it, it controls what you own by yourself in your name without any designated beneficiaries attached. So, and in Colorado, again, this is very state specific. As I'm making this video, this changes a little bit every year because it's adjusting for inflation. But if we get down here in 2021, and what's left to be distributed by this will is worth more than $70,000 or includes real estate, then we have to use a probate court process to get that stuff, to get the authority to transfer those items to the people who are entitled to receive it. So even though we have a will, again, a lot of people think if I have a will, there won't be any need for court. If my family agrees, there won't be any need for court. Not true. If there is this much stuff, your bank or your, the title agent for the house sale or whatever else, they're going to need to see proof that whoever shows up and says, you've passed away and this is, I'm the person entitled to come in here and receive this stuff, that they actually are, and that you have passed away, and that there isn't some will or something else out there saying actually someone else gets it, or some stepchild, some child from a previous relationship or something like that who has some right to receive stuff. So this is enough that the Colorado State Legislature has determined, like, we want to make sure that a court oversees this and really gets make sure the right people get the right stuff. And so again, in Colorado, there's something called the informal probate process. It's a pretty, the courts kind of don't really do much proactively. There's a couple forms they want to see filed, but they're not holding hearings. They're not, you're not filing motions. You don't need, permission from the court to do stuff before you do it as the personal representative. They're just assuming kind of everything's going fine. As long as you've notified the beneficiaries and the creditors, they just kind of sit back. So because of that, again, we don't necessarily tell everybody to avoid probate. But if you do have reasons to avoid probate or just a preference for avoiding probate, we're doing something up here in these first three items. And, you can get a lot done with, co-titling assets, of course, and designated beneficiary forms, especially within marriage. But a lot of people, it's, you really can't. You can't get everything. And again, there's reasons not to co-title assets with kids, for example. So if you want to get that stuff out of your name, the most common way to do that is to put it in the trust, and then that will, again, that's alive and well, whatever condition you're in, and the person that you selected steps in and runs that thing after you've passed away. So that's what that accomplishes. It gives you a way to potentially keep this process private, out of court. There's other things, other reasons to have one. I usually tell people, look, if you have a blended family, so step-kid, step-parent relationships, sometimes, in a lot of marriages, everything happens up here in these first two things. And the survivor between the two people in the marriage actually gets everything. And what that means is really the survivor gets to decide where everything goes. And they might inadvertently disinherit their previous spouse's kids just because those kids are not in their plan, right? So that happens a lot, actually. So if you're in a blended family, you can use a trust to actually control things out a few steps. Say what most people in second marriages want to say, which is support my spouse if I've passed away. But ultimately, I want my kids to get whatever's left after my spouse does pass away. So trust gives you a way to control things out a few steps. A trust also gives you a way, so you have to probate everywhere you own property. So if I live in Colorado, but I own a vacation property in California, for example, to get the Colorado probate court doesn't control property in California. So you actually have to open an ancillary probate out there and get stuff taken care of under their court system, which again, that's a total nightmare. And there's other states that are bad too. So you might want to, if you own property in other states, that becomes kind of a more compelling reason to avoid probate. And then the last thing that I usually point out to people is like, look, this is a court case. This probate process is a court case. And if you have a family member who's difficult, who would use a court case to kind of torment, the rest of your family, which we see sometimes, unfortunately, people who are feeling, it gives them a chance to kind of take out their frustrations with family members. And, sometimes they're actually that's actually the good guy, right? But it's hard to tell for sure when you're in the middle of it. But anyway, because there's already a court case open, it's just very easy for people who feel unhappy with how things are going to just lodge a complaint. It's a small filing fee with the court. They don't have to necessarily even get a lawyer. I see handwritten objections sometimes, and it's just super easy to lodge, kind of throw a monkey in the wrench, or throw a wrench in the process if you're unhappy because you already got a court case open to you. If there's a trust, the whole point of the trust is this court case does not happen. And so you can challenge a trust too. If you're in a family, if you would have received stuff but for a trust that's directing things elsewhere, like you can file a lawsuit and have that investigated too. So you still end up in court, but filing a lawsuit and figuring out what's going on in the trust is a harder process than lodging a complaint in a probate process that is already open. You actually probably need a lawyer to get that process going. It's challenging, and the filing fee alone to get a lawsuit going is almost $300. So much more of a deterrent. So several reasons to have trusts. Like I say, they're not for everybody, but they do. A lot of people do ask about them, and a lot of people do feel like, you know what, I don't have any of those circumstances. I just don't like the idea of my stuff going through a court process. I want to keep it private. I think it can be done more efficiently if my family isn't going through court, and that frequently does turn out to be right, actually. So it can definitely accomplish those things too. So hopefully this helps explain why you might want a trust and kind of shows you where it fits in the process. Even when you have a trust, just FYI, you still have a will. Your will in that circumstance just says, take anything I did not have at the time of my death, put it in my trust then. But your goal is to actually title your assets as much as possible to the trust. For assets that can't be titled to the trust, we'll frequently point the designated beneficiaries at those. Again, these are not hard and fast rules or certain, some in an estate plan, again, it's usually a combination of these things. So sometimes we'll have a trust that is transferring the house and maybe a checking account, but we're using designated beneficiaries to point IRAs directly at people. There's a whole analysis that goes on there. So don't think there's one way to do this, but the trust, you can see all the arrows are pointed at the trust, and then the trust becomes kind of the central location where the instructions are, which can kind of make it a little bit more seamless and a little bit more like if you want to update instructions down the road, you just have this one spot to go to actually do that. When we're doing plans that don't have trusts, we got to make sure that all the things on this list are staying coordinated, and sometimes that will be just a little bit more effort in the future years. So again, hopefully that helps. And if you're interested in potentially getting a trust in place and you're in Colorado, we are happy to have that conversation with you and let you know whether it makes sense for you. So again, we're the Mckenzie Law Firm. Our phone number is 303-578-2745, and we are at themckenziefirm.com, and hope this helps. Thanks for watching.